Hi, I'm John Walter, and I want to thank you for the opportunity to speak in front of our school board this evening. I've been asked to provide an overview of the policies and recent developments with regard to religion in schools. I want to remind everybody that this presentation is going to be strictly based on Supreme Court precedents and established laws and policies rather than my own opinions. So, a recent study from the Pew Research Center has found that public schools remain a battlefield where religious interests of parents, students, administrators, and teachers often clash. The conflicts affect many aspects of public education, including classroom curricula, high school football games, student clubs, and graduation ceremonies. When we talk about religion within schools, there are often opposing perspectives. There are those who believe in freedom of religion. Some of these people are concerned with the federal court's exclusion of religion in school and believe that it infringes on the First Amendment's right to free exercise of their religion, while others believe in a freedom from religion and are concerned that conservative Christians and other religious groups will impose their values and beliefs on students. What's important for us to understand is that religious activities are often happening in school and on school property. 4 in 10 public school students say that they routinely see others pray before sporting events. Slightly more than half of U.S. students say that more often they see students wearing jewelry or clothing with religious symbols. And a quarter of teens in public schools say that they see students inviting others to religious youth groups or religious services. What's important for us as educators and a school system to understand is the constitutional principles. The Supreme Court has repeatedly held that the First Amendment requires public school officials to show neither favoritism toward nor hostility against religious expression. So, there are several Supreme Court decisions that help set legal precedent regarding religion in schools. The first is that the Supreme Court has repeatedly stressed that the Constitution prohibits public schools from sponsoring religious activities. Engel versus Vitale prohibits school-sponsored prayer, and Abington School District versus Shemp has ruled broadly that school sponsorship of religious exercises violates the Constitution. Additionally, in the Tinker versus Des Moines School District decision, the court has ruled that school authorities may not suppress expression by students unless that expression significantly disrupts school discipline or invades the rights of others. The court ruled 7-2 that students do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. And in Wisconsin versus Yoder, the court has ruled that parents have the ability to opt out of certain aspects of instruction if they do not align with their religious beliefs. The Supreme Court found that the Old Order Amish community in Wisconsin had a right to opt their children out of formal education at the age of 14 rather than the state-mandated age of 16 because it burdened their free exercise of that family's religious beliefs. And the courts have also ruled that religious groups are allowed the same access to campus facilities as other groups. Widmer versus Vincent found that the University of Missouri violated the constitutional rights of students to access campus facilities for a Bible study. This caused Congress to respond with the Equal Access Act of 1984 that provides conditions for receiving federal aid for not discriminating on the basis of religion. And the Board of Education versus Mergens upholds the precedent with regard to high school facilities. The courts ruled 8-1 that high schools were indistinguishable from universities for the purposes of equal access to public facilities. So, what we need to be mindful of is the religious rights of students. Students can engage in religious activity and discussion within their responses to homework or classroom-based discussions, and students may pray or assemble on school grounds for religious purposes, typically before or after instruction, and at common events like see you at the poll. Students may not engage in religious harassment of other students on the basis of their religion, and schools may neither favor or disfavor based on religion by providing exclusions or certain privileges on the basis of religion. Additionally, we need to understand that parents and teachers also have rights. We've already discussed that parents have the right to opt out of instruction or events that don't align with their religious beliefs, and public school employees retain the rights to free exercise of religion as well. However, courts have ruled that public schools have substantial discretion to regulate the religious expression during instructional hours because that religious expression could be seen as a sponsorship of religion on the basis from the basis of the school. Additionally, it's important for us to understand the Equal Access Act and the protections that it provides. It finds that student religious groups have the same access to campus facilities as other comparable secular groups, the ability to publicize their meetings through flyers, morning announcements, and the school newspaper. They have the ability to meet on property during non-instructional time, before or after school, or during the lunch hours, and they have the ability to only allow members of their religion to serve in leadership positions if those positions affect the religious content of the group's speech or meetings. So all of this means that there are some implications for religion in school with our current administration. In January of 2020, President Trump said that the government must never stand between the people and God, and has said that public schools too often stop students and teachers from praying and sharing their faith. What's important for us to understand that although President Trump has affirmed his belief in the importance of religious freedoms, he did not propose any changes to existing law or regulations, but simply wants to empower students and teachers to be able to more freely exercise those religious freedoms. This means that schools have to comply with federal law and respect individuals' rights to religious freedoms and not infringe on their constitutional rights. Violation of religious freedom laws or infringement of these rights can result in loss of funding under Section 8524 of the Elementary and Secondary Education Act, as well as open the school district up to potential litigation if a student, employee, or parent feels that their constitutional religious freedoms have been infringed. So that means that as a district, we need to review our policies, focus on compliance with federal law, and provide guidance for other educators. I hope that you will consider the information that I provided today as you move forward. Thank you.